Aging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to Legally Speaking, your YouTube channel brought to you by Aitken Robertson. I'm Melanie van Orde, your paralegal host, and today we are discussing the procedures for youth offenders in the criminal justice system concerning sexual assault cases. Joining me today is counsel Richard Aitken. And if you want to understand these sensitive cases and how they are handled when minors are involved, stay tuned as we delve into the legal process, protections, and implications for young offenders. Hi, Richard.
Good morning, Melanie.
How are you?
I'm doing fine today, thank you.
Richard, what are the age ranges for someone to be considered a youth offender in the criminal justice system?
The age range would be 12 to 17 inclusive. However, an important thing to keep in mind is it's not the present age that matters. In other words, not now, but the age at the time of the alleged offense. In other words, a historic charge from 30 years ago when the person was 14 would be prosecuted as a young offender charge and not as an adult charge. However, if the person was convicted and was sentenced to jail, they would serve the jail time in an adult facility and not in a youth facility, as obviously he would be much bigger and older than the others of the youth facility. It would not make any sense. It would be dangerous probably for everyone.
And then if a youth is charged under the Youth Justice Act, will their case be handled in an adult court or a different court?
In almost all cases, it would be handled in a young offender court, unless, for instance, the Crown, perhaps in a murder case, especially the most serious and egregious of murder cases, applied to transfer it to adult court. So I would say 99.9% of the cases would be in a youth court.
And then what are the key differences between how the criminal justice system treats adult and young offenders?
Young offenders have different rights. For instance, a young offender, when arrested or detained, has the right to have an adult with them, has an opportunity to have a lawyer with them. And I'll deal with the issue of a lawyer for right now. Adults have no right to have a lawyer with them during questioning. A young offender does. However, the problem, of course, is it'd be difficult to get a lawyer to actually attend because they would then be subpoenaed by the Crown, and the client, the youth person, would have to get an additional lawyer at additional cost. So basically, you still have the right to speak to a lawyer. You have the right to have a parent there during questioning. If a parent's unavailable, a responsible adult instead. There's other differences as well. A young person does not have the right to have a jury trial. A young offender, in most cases, will not have the right to have a preliminary hearing. The sentence structure is much different. Minimum sentences do not apply to young offenders. There are certain kinds of cases. Let's say DUI, for instance, is a minimum fine that does not apply to young offenders. There's certain other kinds of serious offenses that have a statutory minimum jail sentence. They do not apply to a young person either. The focus on youth sentences is mostly on rehabilitation.
And then how does the system address the potential vulnerabilities that comes with young people?
As I mentioned before, to get a statement, a confession, or any kind of utterance for a young person, there are safeguards such as a special warning where the accused person is told, as I said, you have the right to have a lawyer present, you have the right to speak to a lawyer, you have the right to have an adult present, you have the right to have a parent present during any questioning. That's a major safeguard. In addition, youth matters have been priority in court, and generally from start to finish will finish earlier than something in adult court.
Can youth be identified as individuals during these proceedings?
In most cases, almost all, there's a publication ban, so you cannot publish, for instance, by newspaper, by radio, by TV, the name of a young person. There can be exceptions. For instance, if a person is violent and at large, a judge might order that the name can be published.
We quickly touched on youth offenders being sentenced to custody. Is that normal for a youth offender to be sentenced to custody?
Very rare for a youth to be sentenced to custody, especially on a first offense. Where a youth gets custody, it's only if it's a really violent offense, or perhaps there's been a number of breaches of bail or breaches of probation, in which case it might happen.
So, Richard, are there any other differences between how youth and adults are being processed through the criminal justice system?
A couple of other important differences. If a young person is convicted of a sex offense, they do not go on the sex offense registry like they would if they were adults. As well, if they were denied bail by a justice of the peace, which does not happen very often, but occasionally does, they're entitled to have a bail de novo in front of a youth court judge. A bail de novo is basically a fresh bail hearing where you do not have to show error of law. It's a fresh start, another chance to try and get bail in front of someone with better qualifications.
Can the Crown seek to impose an adult sentence on a youth offender?
Yes, but only in very rare circumstances, such as a murder has especially aggravating circumstances to it, or something like that.
And lastly, are there any exceptions to the general rule of consent for individuals under the age of 16?
I think you're speaking of sex assaults and the age of consent relating to that, and the answer is yes. Normally, the age of consent for sex is 16. There are exceptions, however. Say you have a 14-year-old young woman, and she is dating and is in a relationship with a 16-year-old male. Assuming she actually consents, there's no issue because they're within 2 years of each other in terms of age. If her boyfriend was 18, it would be a problem. And he could be charged because even if she actually said, I consent, I would like to do this, she's not legally able to consent.
Well, thank you so much, Richard, for joining. And thank you everyone else for joining us today as well on the Legally Speaking Aitken Robertson YouTube channel. Don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website, or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.